Coming up on Sunday night, going to be joined by Carter Clay of the firm Hollis, Wright. Going to be talking about wills. Everybody needs one regardless of income or assets, huh?
That's absolutely right. Statistics show right now that 55% of the adult population is walking around without a will. So that's significant because if you don't have a will and you pass away, your assets and money will be distributed according to how the state wants your property to be distributed. So it's something that everybody needs to pay attention to. We're going to be very fortunate to have Gerald Templeton of the Templeton Law Group here in town. He's a local lawyer. He does a fantastic job. He specializes in the area of estate planning and probate matters, disposing of property upon death. So it's going to be a good show.
An interesting conversation having to do with wills, surprising the number of famous wealthy folks who never have one and why you should not be among that company. Join us on Sunday night. Carter will be here and we'll look for you right after WBTM 13 News at 10.
Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Hello and welcome into the attorneys. We appreciate you spending your Sunday evening with us. What do John Denver, Chris Farley, and Howard Hughes all have in common? Would you believe that all of them died without a will? Tonight, we're going to discuss why it was not only a bad idea for them, but it's a bad idea for you as well to not have a will. We're going to get into that, and we appreciate you joining us for this discussion. Here's how you can be a part of it. We would love your questions relative to our subject matter tonight. Throughout the program, you'll see ways where you can call, text, and email. Would love to have you join the conversation and be a part of our discussion tonight. Leading the conversation, as he often does, Carter Clay from the firm Hollis Wright. Good to see you, sir.
Good to see you, David. I hope you're doing well.
Doing well.
Yeah, this is a topic that affects everybody, including celebrities and musicians.
It's hard to believe.
Nobody is immune from passing away.
That's true.
It is something that we will experience individually, and before we experience ourselves, we will have parents and loved ones that pass away. And with passing away, people die with something.
Right.
Everybody has some type of asset. It may not be very much, but everybody has something. And so the question becomes, how do those assets get disposed of? How are they distributed?
Right.
And that's really the topic that we're going to cover tonight. And in kind of preparing for the show, the statistics are somewhat staggering, I guess. Right now, statistics show that about 55% of the adults in our population do not have a will. And those percentages are even higher when it comes to minority races. It's about 65 to 75% of adults in the population relative to minority races that don't have a will. And so it's a topic that's relevant to everybody, and I think it'll be very informative for the viewers this evening. And thankfully, we've got Gerald Templeton here with us. He goes by Jerry. Jerry, thank you so much for being on the show with us. Tell us a little bit about yourself and your area of legal practice.
Thank you. It's my pleasure to be here. I have been practicing attorney in the state of Alabama for 24 years. Large part of my practice in the last, many years has been estates, probate, estate planning, special needs trust, those type of issues. I have a general practice and I'm located in Homewood.
Okay. It's my understanding, and I think this would be helpful to the viewers to kind of start out in this area, is that everybody's got a will. They may not know it, but they do. The question is, do they want to control the distribution of their assets, or do they want to allow the state to control it? And talk a little bit about the two legal ways in which you can actually distribute or dispose of property upon death.
Okay, sure. It's true. Everybody in the state has a will. You may not know it, but the state has written one for you if you don't write one for yourself to dispose of your property. Everybody is familiar with, I think, or most folks are familiar with, that family members go to an attorney or draw up a will which disposes of their property the way that they want it. They control that process. If you don't do that, the state of Alabama has a series of statutes in our code for intestate succession where your property is distributed based on what the state says should happen to it.
And are there various priorities within the state statute that kind of dictates what percentages go where, whether it be to a spouse or to a family member or to a loved one, that kind of thing?
Sure. It's next of kin, primarily spouse, starting there with then your children, then your parents, and it just goes down. And the percentages that are paid and the factual situations that any person may fall in are all covered, and it gets complicated pretty quick depending on your particular situation. But there is a series of steps that are taken to distribute your property based on what the state says should happen to it.
And so really it's a control issue. Do you want to control how your assets are distributed at death, or are you comfortable with allowing the state to distribute your assets in accordance with their statute?
That's it. You've got to take either control of it, or it's going to be done for you.
What are the most common mistakes? Probably the most common mistake folks make is they don't even have a will. Right? But relative to wills and understanding, what are the most common mistakes or misunderstandings that folks have relative to that?
You know, I think a lot of folks believe that it's expensive. You know, a simple will, if you don't have a large estate, if you just have your basic house, cars, certain properties, you know, some bank accounts, investments, those type of things, drawing or drafting those wills is not expensive, especially if you come in as a couple and do it together. Most attorneys will draft both of those and the documents needed, you know, at a fairly reasonable rate. It's not that expensive. I do it regularly, routinely. I know other attorneys that do it. You usually can give either a free first hour consultation, let somebody kind of figure out what they need either to bring back or if they want to talk to that attorney. So you can go get a lot of advice and a lot of time with the attorney for free, typically, in ordinary. If you're going to do an estate plan, I think now in the modern era, there's three basic documents. A will, of course, to dispose of your property. Before you die, there is a document called a durable power of attorney that I think is usually needed, and I'll talk about that. And the last one is your living will, which is your advance directive for health care. That is, if you've gone in the hospital or had a loved one go in the hospital, in recent times, they've all asked if you have an advance directive. And that is where you tell what should happen to you if you're in a situation where two doctors have determined that you are in a state where you're not going to change. That's a permanent state, what your wishes are. And that's your advance directive, your living will. The durable power of attorney, Alabama passed a revision to its statute 2 years back, I believe, have made some changes to it. So a lot of people don't know that. Even if you've done a power of attorney in the past, you should probably go back to your attorney or call someone and have that revised, because there's specific things now that you need to sign off on. For instance, disposition of real property. You need to check a box or put your initials beside that code section that says that you have the power, or that the agent that you appoint has the power to dispose of property. You may or may not want your agent to have that power, but you've got to say so in that document. Now, that's just one example. There's many things that have changed in those documents that I think in the durable power of attorney that people need to revisit that. So that's a good reason to go see an attorney as well, to have that document drawn up with your living will, and to either have your will done or revised and take another look at it and make sure it's what you want.
Well, what criteria does the law place upon a valid, legally valid will? What criteria do you have to meet to have a legally valid will?
It has to be, you know, there's two ways really of doing it. It has to be in writing by someone who is over the age of 18. You're 19 years of older and of sound mind and not of undue influence, which means that you're free from emotional distress, emotional change, or someone taking advantage of you, or whether it's a loved one or an independent, somebody else. Those are the primary requirements for you to have that, to put that in place.
Does the will have to be witnessed by anybody?
If you want to do it, it does not, but if you don't have a witness, or if you don't have a notary sign the document, there is a different process when you go to probate that will, that someone has to come in and say, yes, I saw this person sign it, and this was their last will and testament. There is a mechanism in Alabama for, it's called a self-proving will, where a specific language is used, two witnesses are there, certain statements are made to those witnesses, and all of it's done with the testator or the person signing the will and the witnesses in front of a notary public. If all those conditions are met, then it's called a self-proved will, which there's not an additional court proceeding needed or hearing where witness testimony is taken to open an estate and have that will probated.
All right, let's take a break right there. Step aside. When we come back, we'll continue our conversation on wills, what you need to know, what are your rights, and some helpful tips for you. Would love to have you join the conversation. Call, text, email. If you call that number that you see right there, 844-LAW-TALK, you can speak with an actual attorney that we have standing by to speak with you. So a neat opportunity to get your question taken by an attorney tonight. But if you'd rather just text in a question or email it, you see ways to do that right there as well. Stay tuned. More of The Attorneys coming right up.
I'm Carter Clay with the law firm of Hollis, Wright. Thanks for watching The Attorneys on WVTM 13. Now we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of this show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to this show or related to other specific legal matters, call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family member. Or simply contact us by going to WVTM13.com and click on the Attorneys link. Now we know your time is valuable, so thank you for spending it with us and for watching The Attorneys right here on WVTM 13.
You'd kind of think a will was something they would have thought of. Welcome back into The Attorneys discussing wills tonight. Would love to have you be a part of the conversation. Call, text, email that information at the bottom of the screen all throughout the program on that subject matter of the firm fact. The question we have here: what if I don't have a great deal of assets? Do I need a will? What if I'm not a Howard Hughes? Do I still need a will?
Well, that's a great question. I'm going to let Jerry take it, because I think a lot of people's knee-jerk reaction is I don't have enough assets to warrant justifying a will and going to see an attorney, but I don't think that's always the case.
It's not. You have particular property that you have that you want something to happen with it after you die. That's the basic question. It's not necessarily a question of value in my mind. It's a question of what you want to do. Is there something you've inherited that you want to pass to from your grandparents or your parents that you want to pass to your children or a certain child? Then yes, you need to take care of that. But as far as a dollar value, no, there's not really any magical number that says that you should or should not have a will. It's always a good idea to do your will if you want your property to go where you want it.
Yeah, we talked at the outset, Jerry, about having a will versus having the state distribute your money, and so sort of implicit in that is, if I have a will, can I dispose of or distribute my property and assets as I want 100%, or does the law still place some restrictions or limitations on how you can distribute your property through a will?
Well, it's the law. There's going to be restrictions. Primarily, the main restriction on drafting a will is you cannot totally exclude a spouse from your property if that spouse so chooses to have what is they're entitled to under the Code of Alabama, and that's typical in most states. But absent some restrictions like that, you get into a circumstance where someone is estranged or they're separated and not divorced, and they have a will in place. Is that what you want to happen? So in domestic relations or divorce type situations, it's another reason to go in and take a look at what you want to happen with your property in case of the pending divorce or the separation. But until you are fully and legally divorced, you cannot exclude your spouse.
Okay. Talk a little bit about, you have a will, the individual who drafted the will, they pass away. What are sort of the procedural steps that you have to go through in order to actually effectuate the distribution of those assets?
Sure. The family member should always know where the original of the will is. There are mechanisms in case you have a copy of a will but not the original that the court can take up. It's a much more complicated and expensive procedure. But a family member or someone should always know where the original of the will is. A lot of folks keep those, the originals in safety deposit boxes, and that is okay, so long as some other person other than the person who's passed away can sign to open the box, and they know that the will is there, for instance. As long as that, you have that in place, then a safety deposit box is a good place to keep the will. I typically keep originals in my office. As soon as the will is executed in my office, I now scan it and send PDF email. So there's a digital copy of that will, and the person who has executed the will can always have a digital copy, send it to their loved ones, their children, whatever they want to do with it. But once the will is filed with a petition for probate, the estate is open and letters of administration are issued to the person in the will who is to direct the next process, the executor or the executrix. Then that person opens the estate. Typically, if you, in your will, you can waive the filing of an inventory, you can waive the requirement of a bond. That's another reason to do a will. In an intestate situation, you cannot waive a bond, which requires money, and the person has to have good credit where they can get the bond. And you cannot waive the filing of the inventory. So there's an expense involved and a time frame involved with an intestate that you can save by drafting in the will. But the estate is open, the letters are open, the executor or the executrix of the estate must then collect all the assets of the estate. Newspaper goes out, you've seen them where it's published for 3 times in the newspaper, local newspaper, for any creditors who may have claims against the estate. Then they would have 6 months from the newspaper notices to file their claim. And so after the 6-month process, the administrator of the estate would have, the executor or executrix would have the assets, they would have any claims that are filed, and then the estate would begin the process to being closed or settled at that time. There are ways to do initial distributions or partial distributions during that time, but the person in charge has a fiduciary responsibility to any heir of the estate, any person named in the will, to get the proceeds of the estate, if you will. They have a duty to them not to do anything that's wrongful or a breach of a fiduciary duty. So they have a special relationship to the people that they are to pay the estate to. So they cannot pay monies to pay claims or prioritize claims prior to the 6 months running, or they could be subject to having to pay that back under their personal funds. So there's kind of a 6-month time frame generally for all that process. Then you go through the closing procedure, file a petition, have everyone, if it can be done by consent basis, where you could have all of the heirs of the estate sign a form saying, I've been paid everything I'm entitled out of the estate, please close the estate. So that's one way to do it. Absent that, the administrator goes in and files all the inventory again with updated information as to assets that they've had, income they've received, payments they've made, and get a net settlement out to the heirs of the estate.
Yeah, and so family members and heirs have to be aware that you have the assets over here, but those assets may be offset by the debts of the decedent at the time they passed away, whether it be credit card debt or any other type of debt that might have to be paid out if creditors make a claim.
Sure, and the executor of the estate has to go, typically you would go and see if there's any judgments filed or any kind of asset, things that are out there that the person who has passed away has been reduced to a judgment where it's got to be paid as well.
Yeah. Time for our final break of the evening. Let's step aside right now. We'll be back here in just a moment as we head to break. A reminder of how you can get in touch with us. Just a few minutes remaining to get your questions in to us. Got one in just now. We'll get that to our panel of experts here in a moment. Also, you can find the firm of Hollis Wright on Facebook if you search that term there. Also on Twitter at Hollis_Wright. Stay tuned. More of The Attorney is coming right up.
I'm Tyler Vale with the law firm of Hollis Wright. In court, attorneys are not allowed to tell juries certain things. For example, we cannot talk about a defendant's net worth, meaning the defendant's ability, resources, or insurance to pay a verdict. In this week's Legal 411, we're answering the question, why can't lawyers talk about a defendant's net worth to a jury? Rule 403 of the Alabama Rules of Evidence states, although relevant, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. Long-standing Alabama cases have held that the net worth of a defendant falls under this catch-all rule. The reasoning behind the rule is that if a jury knows a defendant is wealthy, then the jury might award more money to the plaintiff. And this goes one step further. If an attorney makes any remarks that suggest the defendant is responsible because he is rich and the plaintiff is poor, that can be grounds for a new trial. If you're ever on a jury, the reality in our state is this. In almost every lawsuit that goes to trial, the attorneys representing both the plaintiff and the defendant have already looked at whether there is sufficient insurance coverage or assets to satisfy a verdict. The reality is this: the parties would not pursue a civil lawsuit if damages could not be paid after a jury returns a verdict. So even though lawyers cannot mention the net worth of a defendant during a trial, there could still be resources available to pay a verdict in court. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you.
Welcome back into the Attorneys, our final segment. If you want to join the conversation, maybe a question on wills that you've always wanted an answer for, now's the time to get that into us. Call, text, email, that information at the bottom of your screen.
Jerry, we were talking before the break about probating the will. What assets actually go into the estate that are there for probating and distribution, and are there particular assets or money that's out there that would not be subject to the estate proceedings?
Sure. Most property is going to go into an estate. Your cars, your house, those type of things that are not either in a trust or some other provision have been made for prior to death. Property that doesn't come into an estate is typically life insurance proceeds where there is a named beneficiary, 401ks where there's a named beneficiary, payment on death accounts, bank accounts where the person who's passed away before they died named a person to get those proceeds when they pass away. So anything that has an account that has, the person has where they have named a beneficiary, that is a contractual relationship with that company, whether it's life insurance, 401k, a mutual fund, whatever those accounts are. If they've designated the beneficiary, then that money will pass to that named beneficiary outside of the estate proceeding.
So if I had a will that left all of the property to John, but I had a life insurance policy out there that named Jane as the beneficiary, then Jane would get those life insurance proceeds outside of the estate and regardless of what the will said.
That's correct, so long as the named beneficiary in the policy is not the estate. If they name a person and they don't name their estate, then it goes to the named person.
Okay. Talk briefly about the importance of a will relative to dealing with minor children. Say, for instance, mom and dad tragically pass away at the same time in an accident. What happens to the children if there is no will, and the importance of having a will and dealing with minor children in that scenario?
Sure. You know, there's property involved, and there's the care of the children themselves. You know, care of the children, you have guardianships. You may have somebody that becomes the custodian of the person. There's also a process that is called a conservatorship, which is over the minor's money. So there's two different things there, that guardianship and conservatorship that would be in play. If you have a will, it is simple to draft what's called a testamentary trust, where there's a trust in the will, and the trust does not come into life or doesn't have it come into being until the actual will is probated. But you can make arrangements and provisions for what happens to the minor children's money, and you can even make provisions who should be named as guardian that the court will consider. Those type of provisions that you can make and take care of in your will if you do the planning. But absent that, you have a long court proceeding to establish a guardianship, establish a conservatorship over the money, which is a much more complicated process than having the trust name a trustee who is the fiduciary, the person who the money's paid to, and pays the funds for the benefit of the minor children.
David, I think we have a question from a viewer.
Yeah, a question. This is hot off the presses, but here's the scenario. Let's see if we can help these folks out. This viewer says, my father passed away 6 years ago, left a safe deposit box at a bank. There's 3 of us, so I assume 3 kids, I guess. Do we need to put this in probate court before we can get it? So I guess they're trying to get to a safety deposit box that's at a bank that Dad left behind, that they found out about 6 years after his passing.
The short answer to the question is go see an attorney. There's a couple of issues going on, and I'm not trying to be flippant. First of all, a will to be if there's a will in there, let's say, and there's no estate has been done for their deceased father, well, that should have been probated within 5 years.
Right.
And so the will, you're going to have a tough time of getting that through the probate process. Who knows what's in the box? The bank has a duty there. I presume that they have just discovered this box. They weren't aware of it until now. Don't know, but if you assume that, then the bank is going to have procedures in place to get into that box. Without a court order, it's going to be very hard to get into that box. And so that's back to go see an attorney. Right. You're going to probably need help to find out what to break through the process of the bank to break into the box, so to speak.
Right. Yeah, and the bank's probably not going to do that without some type of legal authority.
They are not, because if they, from the bank standpoint, and in all fairness, if they pay it and they give it to the wrong people, well, then they are just exposed to whatever the property was in there for their own liability. So they're just going to be safe to make sure, and the court order protects everyone all the way around.
Jerry, one thing we haven't talked about tonight that I think is critically important and that I want to touch upon are will contests. An individual or an heir thinks that the will was drafted based on undue influence, maybe by another family member, or that there was fraud in the procurement of the will, or maybe that really wasn't the decedent's last wishes. Talk a little bit about will contests and what goes into all of that.
A will contest is where someone, just like you say, believes that this will was either fraudulently produced through undue influence. The testator was not of their sound mind. I know it's been talked about in the past, but they left everything to their cat. Those type of things that you hear about in the news. I think because it's so rare, it is news. But if you have a family member who has exerted undue influence, has been the primary caregiver, the only relative that's living close by to the decedent, and everybody else lives away, and there's had a will for a long period of time that says one thing, and all of a sudden it's changed, then that will lead to litigation. Will contests can be filed either in probate court or circuit court. There's different procedures, mechanisms involved with either one of those processes. Obviously, again, you're going to need an attorney primarily to do that.
We're just right around 2 minutes remaining, so I want to be sure and give you guys the opportunity just to kind of a last charge and a last thought for our viewers. And Jerry, we'll let you go first. What do you want to leave the viewers with tonight?
There's a lot of reasons to go ahead and to take the time to do your plan. There's 529 savings plans for your grandchildren, for instance. The 529 plans right now, if you look at it, if you have money to leave, you can get like 5 years of your gift tax into the initial deposit of the 579 plan. There's lots of properties that are out there that you can go through and make sure it gets to the right person that you want to have it. There's tax savings, although the estate tax is high now for large estates, but there's things that you should do to make sure that you reduce either the burden on your heirs and that you get the property to them that they want. And that you have peace of mind that you've done your plan. I've just gone through this with my mom. My mom's 89. The Medicaid planning, everything else that's involved with that stage, it is better to go have a plan in place.
This is one of those topics where your knee-jerk response is, oh, I'll deal with that later.
Right.
I'll put it off. I'm not going to die anytime soon. And that's a big mistake, especially for individuals who have significant money, significant assets, individuals who have minor children that are involved. Make it easy on the family, because when you pass away, they're going to be going through the grieving process. They're going to be upset, and it's going to make it so much easier on them if you do that.
Yeah, great way to leave it right there on that note. Appreciate both of you being with us. Appreciate you being with us as well as we wrap things up. If you got a question, didn't get answered, you can get it to us right here. Would love to hear from you, and we'll look for you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by the law firm of Hollis, Wright.